Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases and real-life facts and clients, though of course names are always altered for confidentiality purposes. So for today's episode, we're going to be talking about how many people make the decision to add someone to an asset. And I'm specifically excluding a spouse. Instead, I'm talking about, say, like a child to a bank account or a child on a house, etc. You know, in my little estate and elder law world, a lot of people will ask me, now, Jenny, should I just add so-and-so to my bank account or to my house for XYZ reason? 99.9% of the time, my answer is no. I actually can't really sit here and give an example of when that's a good idea, but we'll go over all of this in detail during this episode, why my answer is no. So we'll get there, I promise. Oftentimes, people add someone to an asset for a pure reason, a good reason. It's not like they're doing this to intentionally cause trouble, right? But the thing about it is that they probably are not understanding all the potential consequences of that action. And that's what we're going to go over today. So since this is a cautionary tale episode, let me give you what happened with the client, the family I'm referring to. In my law firm, if someone has passed away, the first step of our process is for a phone call to be scheduled with the paralegal that works on these type of cases. So whether it's probate, trust administration, etc. The point of the call is that there's obviously legal work that may need to be done after someone's passed, but the purpose of it really is twofold. First, we know there are some questions that if you have the answer to, it sure makes life a touch easier. So the paralegal can help get some, if not all, of those immediate questions answered. Second, after someone passes away, something we always get asked is, what do you all even need from me? So on the phone call, the paralegal can help identify things that still need to be pulled. So like a missing financial statement, maybe calling a financial company to see if there's a beneficiary designated, what documents to pull, etc. So after the phone call, there is a meeting with the attorney that occurs. That way, because you've already talked to the paralegal about sort of the immediate questions and gathered everything you need to pull, the first meeting can be super, super intentional and productive. It's a win for you, it's a win for us. So in this situation, Dad had passed away, and the daughter called the office to get the ball rolling on all this legal stuff. My office, of course, got the call scheduled with the paralegal, and a few days later, the call occurred. And after the call, I happened to cross paths with the paralegal, and she said, "Oh, do I have a Legal Tea podcast episode in the making for you?" So she proceeds to tell me what she discovered in the phone call. That way I can start stewing on how to navigate this upcoming meeting with the daughter. Here's the scoop. Prior to Dad passing away, he added his daughter to a fairly sizable savings account. And I believe it had like $400,000 in it. You see, joint ownership is joint ownership. Technically speaking, the daughter, after the dad passed, is now the only and sole owner of that $400,000 bank account because it defaulted to her at her father's passing. So what does that mean? Well, technically speaking again, she doesn't have to share it with her siblings. Is she required to? Absolutely not. Should she? Well, that's up to her and her conscience to work through. Here in this case, she told the paralegal, "I know for a fact that me taking the entire $400,000 was not my father's intention. I have 5 siblings, and in his will, he wanted everything split between me and my 5 siblings. So even though I could keep it, my plan is to still split those funds equally between me and them. Well, that's awfully generous of her because remember, she doesn't have to. And I'm sure we can all think of the type of people that would 100% keep those funds and say, sorry, siblings, I'm keeping it all. And P.S., a little news flash for some of you out there. I've been doing this for over 10 years now, and I can promise you that the people that say, oh, my kids, my family would never do anything like that. Oh, some of those very people do. I see it happen. Trust me. So back to this cautionary tale. So beyond the fact that the daughter absolutely does not have to share, but she is going to, the stinky part of this is what for her action. She's going basically for her action of going to be gifting out to her siblings, she's going to have to go through some annoying rigmarole to even share with them. And what do I mean by that? Gift taxes. Dun, dun, dun. I really wanted to bring this story up today as a cautionary tale because I thought it would be an excellent time to talk about gift taxes. They are so misunderstood. So here is the scoop. I'll give you the non-legalese, non-fancy way to describe how gift taxes work. Okay, so every person in gift tax world has something called an annual exemption amount, and every person has a lifetime exemption amount. As a baseline, we're going to use 2022 numbers because that's when this episode is being released and recorded. So the current annual gift tax exclusion amount, annual, is $16,000 per person per year. The current lifetime gift tax exemption amount is $12.06 million. So this is how it works now that we have those numbers in mind. Say I give you, Legalty listener, $20,000 today. That is clearly more than my annual exemption amount, right? As the giver of the gift, I have to tell the IRS I gave $4,000 in excess of my $16,000 exemption amount. So I gave $20,000. The annual exemption amount is $16,000. So I gave $4,000 more than that. Following? The receiver of the gift does not report, does not do anything. It's always the giver of the gift. Anyway, to tell the IRS, that is a gift tax return. And this is where people get so confused. They think you'll have to pay taxes on that $4,000. No. Well, not likely at least for a majority of people. That is when the lifetime exemption amount comes into play. Anytime you exceed your annual exemption amount, you are ever so slowly chipping away at your lifetime exemption amount. So they're very much separate, but very intertwined. So what does this mean? Okay, I chipped away $4,000 out of my $12.06 million lifetime exemption. Well, big deal. I often tell people it is okay to give more than the annual exemption amount. People get so latched on to it, and it's because they don't know the piece about the lifetime exemption. So if you do give a gift that exceeds that year's exemption amount, yes, you have to report it to the IRS via a gift tax return. But so long as you have not eaten all of your $12.06 million exemption, lifetime exemption away, it's merely a reporting thing. It's not a paying of taxes thing. Does that make sense? So back to this daughter. She told us earlier she had 5 siblings. So let's do the math. There was $400,000 sitting in that account. That means each sibling should get around $66,666. What a bad number. The daughter will have to do 5 gifts of $66,666, meaning she's going to have to, 1, file gift tax returns stating she gave about 50 in excess of her annual exemption, which is just annoying for her. And second, that 50,000 times 5 is like 253,000 that she is now chipped away at her lifetime exemption amount. Which, that may not sound like a huge issue, but you're probably thinking that because, like I said earlier, the lifetime exemption amount is $12.06 million per person. Oh, and by the way, that's per person. So for a married couple, you get close to $25 million. But what if they changed the gift tax lifetime exemption amount? Which there are current proposals making that so. Even if the proposals actually do not happen, the current exemption amounts are actually supposed to sunset back to the original amounts, subject to inflation. And that's supposed to sunset back in 2025, 2026. So the issue here is changes in the law. So this story is a cautionary tale because the dad that passed away here could have still gotten that $400,000 to all of his children and done so in a cleaner, nicer manner. So let's talk about that. There are 2 ways to tackle this. One is a cheaper upfront, costly on the back end method, and the other method is a more expensive upfront, less costly on the back end. Let's remind ourselves before we dive into these methods that let's remind ourselves what these methods accomplish. First, it accomplishes not putting that decision on one person on whether to share or not. As I said earlier, we probably all know people that would have taken the $400,000 and ran and not split with siblings. Second, if the person does decide to share it, it accomplishes that person not having to file gift tax returns. Not only is it somewhat annoying on that person, but they also should be wise to use an accountant to do so, which means an unnecessary expense to them. Third, again, if that person does decide to share, it accomplishes that person not having to eat into their own personal gift lifetime exemption. Why should they have to eat into theirs due to poor planning on your part? And finally, if we do it the right way, which is what we're going to talk about next, you will preserve your tax basis, and your kids, so long as it remains in the current tax law, will get what's called a step up in basis, meaning they won't get hit with capital gains taxes. And side note, we've talked about capital gains taxes and step up in basis in past episodes, so if you've hung with me through all these episodes, you've probably heard me talk about it. We most recently talked about it in episode 45, Medicaid myths. So if you want to take a listen and learn a thing or two about it, take a listen to that episode. So back to the options, the methods. The first method, the one that is cheaper up front, costly on the back end, is to leave this account in your name only and have a last will and testament prepared. So long as the account remains in your name at your passing, and that account will be governed by your will. Wills are cheaper every day of the week to prepare than the second method we're going to talk about. But wills have to be probated and taken through the probate court process. And that probate court process can get costly, which we've also talked about a number of times on Legal Tea. The second method is to create something called a living trust, a revocable living trust, an asset protection living trust, and state that anything in that trust at your passing gets split how you want. While trusts are more expensive to create than wills, trusts avoid probate, so long as your assets are held in the name of the trust. So that means no or very minimal fees after you pass. P.S. Before we wrap up this episode, I'd be doing a disservice if I didn't mention this. So there are other ways to pass assets to beneficiaries, like through beneficiary designations. But there are sometimes logistical challenges that those pose. And we don't really have enough time to dive into those today, but if you go back to episode 36, if you have a few minutes, go check that episode out where we talk about beneficiary designations there. Alrighty, let's wrap up this episode. Next week, we are back to the current events, current trends topic. Something I've seen or run across that I think would be super interesting to chat about on here. During that episode, we're going to be talking about assisted reproduction and how my little estate elder law world sometimes gets involved, and maybe unintentionally. So we'll be diving into that next time, Legal Tea listeners. Until then, be well and talk soon.